welcome back to another episode of Courts This Week presented by Livelaw. I'm your host Ostika Das and I'm excited to take you through the most important legal developments from last week. In this episode, we are going to talk about the Supreme Court stay on the conviction of Congress leader Rahul Gandhi, the latest development related to the Gyanvapi Mosque case, communal violence in Nuh in Haryana and the Apex Court's reaction to it, and more. Let's begin. The biggest development last week is the stay on the conviction of Congress leader Rahul Gandhi in a criminal defamation case over his "Why all thieves have Modi surname" remark. A three-judge Supreme Court bench of Justices B.R. Gavai, P.S. Narasimha and Sanjay Kumar heard and allowed Gandhi's plea challenging the Gujarat High Court's refusal to stay his conviction, which resulted in his disqualification from the Lok Sabha. For context, this remark dates back to a political rally in 2019. BJP MLA and former Gujarat Minister Purnesh Modi had filed a complaint under sections 499 and 500 of the Indian Penal Code over this alleged remark, accusing Gandhi of defaming everyone with a Modi surname. The scion of the Gandhi family approached the Supreme Court after he was turned away by a local court in Gujarat as well as the High Court in the state. In a major relief to the Congress leader, the Supreme Court on Friday issued a stay on his conviction, and the Lok Sabha Secretariat on this Monday issued a notification restoring his membership of the lower house of the Parliament. After the Allahabad High Court gave the green signal to the Archaeological Survey of India to conduct a scientific survey of the entire premises of the Gyanvapi Mosque in Varanasi, the Supreme Court has refused to interfere with this order. However, this order was passed by a bench headed by Chief Justice D.Y. Chandrachud only after taking on record an undertaking made on behalf of the Archaeological Survey that no excavation will be done at the site and no damage will be caused to the structure of the mosque. To give you a quick background, a single judge bench of Chief Justice Pritinkar Divakar of the Allahabad High Court upheld an order passed by a local court in Varanasi directing the ASI to conduct a scientific survey of the entire precinct of the mosque, barring the already sealed Wuzu Khana or ablution pond. Chief Justice Divakar said that this survey of the disputed site was necessary in the interest of justice and it would benefit the plaintiffs and defendants alike, besides coming to the aid of the trial court in arriving at a just decision in this matter. This order has now been upheld by the Supreme Court, which refused to interfere under Article 136, subject to the ASI survey being carried out non-invasively. The Supreme Court last week issued certain orders with respect to the rallies by the Vishwa Hindu Parishad and Bajrang Dal in the Delhi NCR region in response to the communal violence witnessed in Nuh in Haryana, which eventually spread to the neighbouring Gurugram. An urgent application was moved in the top court on Wednesday, which was heard by a special bench on the same day. Taking note of the apprehension expressed by the applicant that the rallies and marches would lead to large-scale violence, the top court categorically instructed state authorities of UP, Haryana and Delhi, including the police, to ensure that no violence breaks out, that there are no instances of hate speech, that adequate number of police and paramilitary forces are deployed wherever required, and that CCTV footages are used and videos shot in sensitive areas and the footages preserved. After issuing these guidelines, the court directed the matter to be listed on 4th August, that is Friday. On Friday, the bench headed by Justice Sanjeev Khanna adjourned the hearing, but not before issuing a call to action to stakeholders to find an enduring solution to the problem of hate speech. He stressed that all parties needed to sit together and come up with a solution to tackle this problem, one that would allow victims of hate speech to access meaningful remedies without coming to court. One suggestion that Justice Khanna offered during the course of the hearing was that police forces needed to be appropriately sensitized. Manipur has been witnessing ethnic clashes since May. After the internet shutdown that was in effect in the state was lifted partially, one of the first videos that emerged was one depicting two Manipuri women being paraded naked and sexually assaulted. This led to the Supreme Court taking suo motu cognizance of the video and the situation on ground. After receiving inputs from the concerned authorities, the Supreme Court has slammed the investigation carried out by the Manipur police in relation to the ethnic violence, calling it lethargic. The top court even went to the extent of saying that there is an absolute breakdown of law and order and machinery of the state. Chief Justice D.Y. Chandrachud also indicated that the court would constitute a committee of former judges of the High Court to make an overall assessment of the situation, rehabilitation of the people affected by the violence, restoration of homes, besides ensuring that the pre-investigation process relating to the recording of statements proceed in the proper way. This committee was constituted on Monday and it comprises 3 retired women judges from High Courts. The Supreme Court commenced hearing the batch of pleas challenging the abrogation of Article 370 of the Constitution, which stripped the erstwhile state of Jammu and Kashmir of its special status. The Constitution bench comprises Chief Justice of India D.Y. Chandrachud and Justices Sanjay Kishan Kaul, Sanjeev Khanna, B.R. Gavai and Surya Kant. Senior advocate Kapil Sibal has argued that Article 370 is no longer a temporary provision and that it had assumed permanence post the dissolution of the Constituent Assembly of Jammu and Kashmir. The senior counsel contended that Article 370 was placed as a temporary provision under Part 21 of the Constitution because the Constitution makers foresaw the formation of the Constituent Assembly of Jammu and Kashmir, and it was understood that the Assembly would have the authority to determine the future course of Article 370. He argued that the concurrence of this Constituent Assembly was a prerequisite for the abrogation of Article 370, and in view of the historical context surrounding the instrument of accession and the constitutional relationship between the state of Jammu and Kashmir and the Indian government, any residuary power now lay with the state government of Jammu and Kashmir. At the end, Kapil Sibal also argued that under Article 3, it was impermissible to convert an entire state into a union territory, assailing the move to reorganize the erstwhile state of Jammu and Kashmir into 2 union territories, the Union Territory of Jammu and Kashmir and the Union Territory of Ladakh. Multiple petitions have been filed in the Supreme Court of India challenging the decision of the Patna High Court to uphold the Bihar government's caste-based survey. This verdict was delivered by a division bench of the High Court, which rejected the contention that an attempt to collect data on the basis of caste amounted to a census and held the exercise to be perfectly valid, initiated with due competence. The petitioners include Akhilesh Kumar and non-governmental organizations Ek Soch Ek Prayas and Youth for Equality. The petitioners have inter alia reiterated before the top court that the exercise being carried out by the Bihar government amount to a census that only the union is empowered to carry out owing to the operation of entry 69 of the 7 schedules list 1 read with the Census Act 1948. The petitioners have also raised concerns over the possible infringement of the right to privacy, which has been held to be a part of Article 21 in the 2017 Case Puttaswamy judgment. In a setback, the Supreme Court refused to immediately grant interim bail to Aam Aadmi Party leader and former Delhi Deputy Chief Minister Manish Sisodia. He had sought interim bail on humanitarian grounds on account of his wife's deteriorating health condition leading to her hospitalization. According to reports, Seema Sisodia suffers from a chronic autoimmune disorder. A bench headed by Justice Sanjeev Khanna said that it would be considering the interim bail application along with Sisodia's regular bail plea and adjourned the hearing till September 4. For more context, Sisodia is facing charges of money laundering and corruption for alleged irregularities in the framing and implementation of a now scrapped liquor policy in the national capital. The AAP leader has been in custody since February of this year and is being investigated by both the Central Bureau of Investigation and the Enforcement Directorate. The Supreme Court granted interim bail to M. Shiva Shankar, former Principal Secretary to the Chief Minister of Kerala, for 2 months on medical grounds. Shiva Shankar had approached the top court seeking bail in a money laundering case in connection with the Life Mission corruption case on grounds of ill health. Life Mission project, for those who don't know, with life standing for livelihood, inclusion and financial empowerment, is a housing project initiated by the Kerala government for the homeless. The interim bail was granted by a division bench of Justice A.S. Bopanna and Justice M.M. Sundaresh on the ground that Shiva Shankar required surgery and post-operative care. However, the Apex Court made it clear that he cannot visit any other place other than the hospital and his home during the period of bail. The Supreme Court has rejected a PIL challenging the appointment of Arun Goel as a member of the Election Commission of India. This public interest litigation was filed by the Association for Democratic Reforms and alleged irregularities in Goel's selection process. However, a Supreme Court division bench led by Justice Sanjeev Khanna emphasized that the recent Constitution Bench judgment found no fault with Goel's appointment, making it unsuitable to entertain the PIL at this stage. The Supreme Court has appointed former Delhi High Court Judge Jayant Nath as the chairperson of the Delhi Electricity Regulatory Commission on a pro tem basis. This is an ad hoc measure adopted after the Delhi government and the Lieutenant Governor failed to sit together and decide on a name. For more context, the Aam Aadmi Party-led Delhi government has challenged Section 45D of the GNCTD ordinance, which has now become an act, that stipulates that notwithstanding anything in any other law, all authorities, boards, commissions and statutory bodies in and for NCTD shall be constituted by members appointed by the President of India. The list of bodies includes the Delhi Electricity Regulatory Commission or DERC and the appointment of former Allahabad High Court Judge Umesh Kumar as the DERC chairperson was also challenged before the Supreme Court. The Delhi government accused the Lieutenant Governor of unilaterally proposing Justice Kumar's name without its concurrence. Can the newly formed opposition alliance called Indian National Developmental Inclusive Alliance or INDIA use this acronym? The Delhi High Court has issued notice on a public interest litigation against the use of this acronym and sought the responses of the Union government through the Ministries of Home Affairs and Information and Broadcasting, Election Commission of India and the 26 political parties who are a part of this alliance. The plea seeks a direction to the political parties to not use the acronym INDIA and also on the Election Commission of India and the Union government to take necessary steps in this matter. The Allahabad High Court has served a notice to Samajwadi Party leader Azam Khan in an appeal filed by the Uttar Pradesh government against the Rampur court's order acquitting Khan in the 2019 hate speech case. The case led to Khan's disqualification as an MLA last year. The bench headed by Justice Rajbir Singh has also summoned the trial court records. The matter is scheduled for further hearing on September 27, 2023. Earlier this year, an additional district and sessions judge overturned the conviction in sentencing, setting aside an order from a special MP-MLA court that found Khan guilty of making provocative remarks against the Chief Minister and the then DM during the Lok Sabha elections of 2019, resulting in his disqualification as an assembly member. We have come to an end of this episode. But before we go, I have a small appeal from the team here at livelaw. We are an independent, fact-driven media organization that is committed to fearless and ethical journalism. And in order to survive and keep bringing you your daily and weekly doses of legal news, especially in an audiovisual format, we need your support. Therefore, don't forget to do the 6 things we always ask you to do. Like our video, share it with your family, friends, classmates and colleagues, subscribe to our YouTube channel, comment your thoughts and feedback below, hit the bell icon to turn on your notifications, and finally, visit our website www.livelaw.in to read our detailed reports. I'm your host Ostika Das and I will see you again next time.